During timelines 1 and 2, I left you right around the end of October. Well, this is a look back at that hearing. Watch the belly. She's about to move it in ways that actual bellies don't move in. Yeah, they don't bump up like that. No, not at all. Interesting. Very interesting.
I don't think that request should be granted.
I
Well,
don't know that I can do that officially. I think that we can.
the last hearing was continued till November 2nd, but before we can get to November 2nd, we have to go to November 1st. On November 1st, there was a protection order. There was a request for civil harassment restraining order filed against Dave Neal. It said, Mr. Neal has mentioned my mother on YouTube, Patreon, and on his podcast several times, and he has said he is looking into her involvement in my current pregnancy, which is not only senseless and intrusive, but she is a private citizen, an award-winning journalist who wants nothing to do with Mr. Neal. Oh, her relationship is that Mr. Neal is a popular YouTuber and podcaster who has spread false information about me. She lives in Arizona and is being cyberbullied by Mr. Neal, who lives in Los Angeles. That is not the definition of cyberbullying. Tens of thousands of people who are his fans on YouTube of his podcast and who are actively involved in Reddit. That's the description of the harassment. Oy vey. She has experienced, you know what, thoughts due to helplessness I feel in regards to Mr. Neal spreading misinformation about my reproductive history, despite providing him with undeniable proof of my prior pregnancies. Oh, Lord. He has refused to believe it and has continued to create content alleging that I faked pregnancies, which is untrue and proven by medical records I provided him with, and I've received messages that have made me have depression, anxiety, and sleepless nights. Well, when you get an ultrasound from Fiverr, this only started when I became pregnant with Clayton Echard's twins. Mr. Neal's content is all about the TV show The Bachelor, and Mr. Echard was a star on the show. She would like for him to stay 100 yards away from her vehicle, the people listed somewhere else, and her home, even though he lives in another state. He's been posting defamatory content against her, and she wants it to stop immediately. He has been warned if he does not stop making this content, defaming me in an effort to gain favor with Mr. Echard, that I would be obtaining an order. Yet it has not stopped him, because that shouldn't be grounds to obtain an order. So he runs a channel, blah, blah, blah. His sources are two men who I have restraining orders against, who have had similar situations. There's nothing scandalous about it. Yeah, there is. Oh, I am a popular, no. Self-help podcaster, no. Oh, Lord. False information, no. I'm pretty sure there was actual receipts to back it all up. After being the most watched American TEDx talk when it was released, I would like to see proof of that, please. Mr. Neal's fans went on YouTube and posted such negative reviews, I had to ask Ted to turn off commenting, which they did since they were personal attacks and not based on the speech. Well, if the speech was based on a lie, I have attempted countless times to get Mr. Neal to stop the cyberbullying and cyber harassment. Well, he's not really doing that. He's being a reporter and reporting on something that's happening. He even started a GoFundMe, which he is allowed to do. He has gone so far as to insinuate I intercepted a blood sample. Oh, jeez. In an effort to prove I was pregnant and get him to stop reposting defamatory comment, I sent Mr. Neal a photo of me showing my pregnant stomach. Rather than take this into account objectively, he posted it on his YouTube channel and analyzed it. This meets the standards of revenge porn. Just because Commissioner Duty thought you wouldn't post it yourself, I don't think that meets the standards. I need to look at the standards. Depends on what state you're in. You know, if you wanted him to stop the harassment, you should have dropped the fake lawsuit. That would have been such an easy way to fix this. I mean, I don't really know what else to say. I request that Mr. Neal is forbidden from posting information related to my current or prior pregnancies, which is related to my personal health. I had 2 abortions. You're putting that in a public document. Why? That he has reported on that has caused me harassment. I would request that he no longer report unverified information about me. You just verified it in a public document. By that I mean information provided to him by 2 men I have protective orders against. That doesn't mean they can't provide him with factual information. I understand that Mr. Neal has First Amendment rights and that the line between protected speech and protected conduct is blurry. However, he has crossed the line several times in regards to cyberbullying in California, such as cyberstalking. His pattern of conduct is intended to harass, annoy, and threaten me. I'm being targeted because of my very private reproductive history. And she says it again. Why do you keep saying it? Yeah. She digs this hole and then gets mad when it collapses in around her. I don't understand it. So, following the filing of that harassment order against Mr. Neal, then we're back in court. But fortunately, this time, both sides have counsel, and it doesn't go quite as smoothly.
All right. So good morning. I'm Commissioner Jones-Fitz, and we're here today in the matter of Clayton Echard versus Laura Owens, CV 20230539552. We will start by having everyone state their names. Ms. Arena, if you want to begin.
Good morning, Your Honor. Deandra Arena, counsel for the plaintiff, Clayton Echard. I'm also accompanied by Isabel Rainey from my office, who's an associate.
You, Mr. Echard?
My name's Clayton Echard.
Thank you. Yes.
Good morning, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present before the court on Microsoft Teams.
All right, thank you. Ms. Owens, if you can state your name for me.
Laura Owens.
All right, thank you. All right, so this is the continuation of the contested hearing that the previously held on October 24th. Before we start, I guess we'll discuss that there was a request to have the hearing not put on live stream. The court granted that. Then there was an objection to that filed. The court had granted it prior to the objection, but I have reviewed the objection. At this time, I'm still ordering that the live stream not be active during the hearing. The courtroom is still open. Anyone who wants to come to the courthouse can view the hearing in the courthouse, but I'm not having the hearing live streamed. We also had a notice of supplemental allegations filed on October 31st. Mr. Lopez, did you have an opportunity to review that?
I did have an opportunity to review it, and I'd like to object on a handful of different reasons, Your Honor. And if you'd like, I can present those now.
Sure.
So in regard to the amendment, well, in regard to the amendment, Your Honor, generally what happens in these order of protection hearings or injunction against harassment hearings, the petitioner is able to amend their petition at the beginning of the hearing before we've even started to determine what the scope of the hearing should be in regard to. In this particular instance, Clayton did not have those in his petition, and we are now 4/5 of the way through his petition. Not only that, we've started the hearing, and he's ended his case in chief. We've already presented now. He's ended his testimony. He's ended entering his exhibits. We've moved on to the defense case in chief, and we're 4/5. Again, we're 4/5 of the way through the hearing. If this was all complete on the same day, he wouldn't get that opportunity to now amend his petition once we're already about to be at the end of the hearing. Just because he's now hired counsel doesn't give him a new opportunity to now amend the petition or add exhibits or add testimony. That would essentially be restarting this whole hearing over again, opening up the petitioner to be able to testify and then cross-examination, and then we would get a chance to respond. That wouldn't make any sense. It's too late now. He shouldn't be able to amend the petition at this point.
If you wanted to be heard,
I do, Your Honor, and
you can remain seated.
Okay.
It's better for the microphone anyway. So
whatever the court's preference is, of course. Your Honor, with respect to our request to amend pursuant to Rule 38D, it's our position that we are able to amend at this point in time. Mr. Echard has already provided testimony to support these new allegations in his case in chief. I believe the purpose of Rule 38 is in part for judicial economy. As the court's well aware, Mr. Echard could proceed with filing an additional injunction against harassment at a later date. So we're really just doing this to ensure that the court has all the necessary allegations to proceed with making a determination in this hearing today. I don't believe it's prejudicial whatsoever. Again, the testimony has already been provided to support these new allegations, and I think it's important that they be added so that the court can make a determination today and Mr. Echard doesn't have to come back another time with a new injunction.
all right, thank you. So when I first received it, I was concerned that we were, just adding stuff at the last second. I do think that these are just making more specific allegations that we did discuss, that Mr. Lopez did have an opportunity to cross-examine him about because they were based on exhibits that were already admitted and have already been admitted at this time. So I will allow the amended allegations at this time over the objection. But I do have the same concerns Mr. Lopez expressed, which is we're not restarting this hearing. And so the reason we reset it was so that Mr. Lopez could ask Ms. Owens questions about their exhibits and admit whatever exhibits they were choosing to admit. Mr. Echard, I have given him an opportunity to review those exhibits prior to those being admitted, since he hadn't had an opportunity to see those. So where we are in the case is that Ms. Owens has testified primarily. She is going to, finish her testimony through whatever exhibits Mr. Lopez wants to admit. And then Mr. Echard would have the opportunity to cross-examine Ms. Owens because that part he hadn't concluded yet. And then we would do closing arguments. So that's kind of where we are. Okay.
Just a question, Your Honor. So I understand that you're going to allow the amended petition, but as far as the exhibits that the petitioner was trying to supplement, those are not being included. Is that correct? He's not getting the opportunity to admit additional exhibits. Is that correct?
I mean, I guess the only thing I have about the exhibits, and I haven't seen that, I haven't reviewed all of those exhibits. The only thing I don't know about any of the exhibits is if they were in response to any of the exhibits that you have, I guess is what I'm not.
I guess I'm not sure either.
I guess that's the only thing I don't know, but at this point I do think his, case has been basically concluded.
Okay. My final question is, as far as this hearing, I know it indicates in the minute entry it was, we were just going to go for 30 minutes. Is that 30 minutes altogether? Is that 30 minutes for us to present our exhibits? Is that broken down? I just want to make sure that I'm efficient with my time as best I can be.
I mean, ideally we're here for 30 minutes, but I will extend it to 45 minutes to allow everyone to do closing. So the testimony portion, and that would include cross-examination time, would be the 30 minutes. Okay.
Is it, do I have 20 or is it like 15 and 15? I just want to make sure.
20 is fine, and then 15, 10 minutes to cross-examine if we need to, and 15 minutes for closing, sort of around that time.
All right. Thank you.
Okay. Ms. Rena?
Your Honor, with respect to the exhibits, the supplementals, they are, for the most part, impeachment exhibits with respect to Ms. Owens' prior testimony. So that's what they would be using for. And so I guess to answer the court's question, they are responsive to defendant's exhibits here. So it would be utilized for cross-examination. That's what the supplemental exhibits are for.
And I mean, I think you could use them for impeachment purposes if you felt they would be relevant. So I just don't know if she has them to look at.
They were disclosed to Mr. Lopez on, I believe, yesterday morning.
I was able to send them to my client, Your Honor.
Okay, thank you.
And Your Honor, one last thing. While I understand and respect the court's decision regarding the courtroom being closed for live stream, I do have concerns regarding the fact that Ms. Owens is present virtually and who's present, in her household and who else is being able to listen to this. My client, unfortunately, with this hearing not being able to be live streamed, is being precluded from having any of his family, friends, or any other persons that may want to listen in support of him from being able to do that. So I would just ask that the court at least confirm with Ms. Owens that no one is present. I know this is hard to confirm, but that's one of our concerns.
Okay. I'm not sure. I mean, obviously his family can be here, and I'm not sure it looks like he has some people here, but Ms. Owens, is anyone else with you?
No, I'm in a casita by myself.
Okay.
I can also pan if they want to see that nobody else is present, if that would be helpful.
Okay. All right. Thank you. All right. So, Mr. Lopez, you may proceed.
Yes, Your Honor. I want to turn the court's attention to, and I'll jump around here a little bit, but Exhibit 38. And, Your Honor, do you have that available? It's a video. Do you need a USB?
You can hook up to your computer to show it. I can make you a presenter.
I can play it on my computer. Is that what you need? Because I can bring it up there.
Yeah, if you want to present it, then I can make you a presenter, and you can. Well, actually, because I think you need the little hookup thing to that.
Yeah, there were some technical difficulties. I want to either say last time or in a different court. I could try and do that. I don't have the.
You know, best if you can bring in those hookup things.
What was that, Your Honor? Sorry.
I'm trying to get my JA to bring in the little extra extension thing that I think you need. Sure, as long as everyone can.
Okay.
Serena wants to come up and see it too. Or?
Okay. Laura, do you have in front of you exhibit that's marked 38?
I believe I know the one that you're referring to. I don't have it in front of me, but I believe it's the video of my pregnant stomach. Is that correct?
I believe this is the video she's referring to. This was sent to, I'm not sure who, Clayton and somebody else as proof of pregnancy.
Yeah. Is this an accurate video of you?
So it's actually not showing up at all on mine. Your Honor, I can see you and I can see Mr. Echard's counsel, but I can't see my attorney or anything else.
You can't see me?
No,
if you can maybe just put it near the lap, we might be able to see it just on the screen there.
What she's saying, she can't see all the participants.
She can see you. Well, can you see him now?
I cannot. I can only see you, and I can see Mr. Echard's counsel.
I mean, I can maybe unmake you a presenter because I think maybe that's what happened. Can you see him now?
I cannot.
Can you click something on your screen, like participants, or a different view?
Let me see.
Okay, gallery, whatever.
No, nothing else. Nobody else is showing up.
Okay. Despite you being able to see me,
Yes.
you have in front of you Exhibit 38.
The video of my pregnant stomach.
Yes. What is this?
It's a video that I took of my pregnant stomach because Mr. Echard asked me to take it for him so he could verify that I was indeed pregnant.
Okay. And is this video an accurate reflection of what you looked like recently?
In September, I believe.
And is this a video that Mr. Echard asked you to send to him?
Yes, it is.
Was that to show proof that you were in fact pregnant?
Yes.
Okay. Your Honor, I'd like to move into evidence Exhibit 38.
Your objection, I don't believe sufficient foundation was laid. Also, this video does not have any time or date stamp on it to be inherently reliable.
I mean, I can't see it, but
Is there any way, Your Honor, for the video to be played on the Microsoft Teams?
so that's what I think we were trying to have him do with that, the hookup thing, but I don't know specifically how to do it. Beth, do you know how to hook it up or no?
I do not, but I can ask next door.
Do you know if Clayton had changed his number since he had texted you from that number previously?
No, he had not, to my knowledge.
Okay. And these text messages, were they sent to you during the time periods between when you became pregnant to when this petition against you for this injunction against harassment was filed?
Yes.
Are these accurate reflections of those text messages? Have they been altered in any way?
They have not been altered in any way.
Okay. Your Honor, I'd like to admit into evidence Exhibit 40.
Any objection?
Sure, I'm objecting for the record. I think there's a completeness issue here. These text messages have been altered. As the court can see, these text messages only include the statements that Ms. Owens wants to include here, not the context surrounding the text messages. I also believe that there hasn't been sufficient foundation laid with respect to the actual dates that these text messages span.
All right, I'll admit 40 over objection.
All right, I'd like to turn your attention now to Exhibit 47. Do you have Exhibit 47 in front of you?
Yes, I do.
And what is this exhibit?
This is an email I got from Clayton on September 17th saying that he was unbothered by me going to the media about the situation.
Okay. Now, you said when was this email sent to you?
September 17th.
And it was your understanding that it was sent from Mr. Echard?
Yes, correct.
Okay. And what was this email in response to?
This was in response to me saying that I had told him that if he didn't continue to participate in the paternity case, that I felt like I was going to need to go to the press because I thought that would pressure him to come up with a parenting
Objection,
plan.
Your Honor. She's providing a narrative that's not part of this exhibit. Again, this is a completeness issue here. She is cutting out the portions she wants and leaving out the context, which would be the email that she sent him that he is responding to.
I'm only
If you want to present the other half of it, obviously you can. I would go ahead and admit exhibit, what are we, 40?
Okay. Your Honor, yeah, at this time I'd like to admit this exhibit.
47, it'll be admitted.
Okay. I'd like to turn your attention to Exhibit 37. This, again, is... what is this?
I do not have Exhibit 37 in front of me.
It should be a video.
Can you possibly give me the context for which video it is? Or
It should be a video that was posted by Clayton.
oh, okay. Yes, I know exactly the video. It was a video that Clayton posted on October the 6th on his public.
What is this video?
This is Mr. Echard telling his 200 and nearly 300,000 followers that the results of our paternity testing were back and he was not the father when, in fact, the paternity test results were not back.
Okay, so you had done a paternity test?
Correct.
The results are not back?
The results are still not back. The testing is ongoing according to the lab.
But since the paternity test had come back, you are indicating Clayton had posted a video?
Correct.
Where was that video posted?
I'm sorry, did you say where or when?
Where?
It was posted to his public Instagram.
When was it posted?
October the 6th.
Okay, how did you get a copy of it?
I got a copy because it was on his public Instagram.
Okay, and was this an accurate have you altered the video in any way?
No, I have not.
Okay. Your Honor, I'd like to admit Exhibit 37 into evidence.
Sir, I'm objecting on relevance. This case is about Ms. Owens' harassment of Mr. Echard. Mr. Echard posting anything on his private social media is not relevant to this case.
Your Honor, as part of the petition that Mr. Echard had written, he had indicated that my client was defaming him when in fact my client was not defaming him and that she was harassing him by sending him emails and different text messages. I think that this is relevant to show that not only were the text messages and emails concerning my client's pregnancy, paternity, but also what I had indicated in my opening and evidence that we had Ms. Owens testify to, that she did in fact also message Clayton to take down certain false videos or false statements offline because she was getting harassed by his fans and followers. So this video is to show that this was the video that he had posted, and the reason she had continued communication with him beyond just the pregnancy and paternity was for him to take down certain videos, that it wasn't for harassment and that it was for legitimate purposes. This is that video that we want to present to show why my client was communicating with Clayton regarding that specific issue.
All right, I'll admit the exhibit for the purpose of that limited purpose that you're referring to.
Listen, it's Friday, and you know what we need on a Friday? We need some good news. And who's got the good news today? I got the good news. What's that good news, Clayton? Well, test results came back early, and they said little to no fetal DNA present. Let's go, baby. We knew, I knew that was going to happen. Thankfully, 5 months of torture can finally be put to rest. I want to say thank you all to those that have supported me and waited until everything came out. And man, 2 false accusations in 2 years. I really don't want to, look ahead to next year and see what's going to happen. I think 2 false accusations in a lifetime is enough. So thank you all for the support, the love. This was a trying time, but I learned so much about myself. And now back to the regular scheduled programming, baby.
Back to the regularly scheduled programming. And listen, it's Friday.
About 5 more minutes.
All right, I'd like to turn the court and Ms. Owens, I'd like to turn your attention to Exhibit 44. What is Exhibit 44?
Exhibit 44 is a text message I received from Clayton on June the 4th.
Okay. And was this, okay, this was from, is this a text message or is this an email?
This is a text message.
Is this an accurate reflection of the text message? Has it been altered in any way that Clayton had sent to you?
No, it has not been altered, and yes, it is accurate.
I don't see a phone number in here. Was Mr. Echard's phone number saved as Clayton Echard in your phone?
Yes, it was at that point.
Okay. And, Your Honor, I'd like to admit Exhibit 44 into evidence at this time.
Any objection to 44?
Your Honor, I would just object for the record as to completeness. Again, I believe there is more to this text message than what is being disclosed in this exhibit.
All right, I'll admit it over objection.
Okay, I'd like to turn to Exhibit 46. Ms. Owens, what is Exhibit 46?
Exhibit 46 is a variety of different medical providers that I saw confirming that I am, in fact, pregnant from the day I found out I was pregnant on June 1st through, I believe it was last week. It may have been through the week prior to that, but I have the dates on there through October 11th. Yeah, I'm sorry.
Okay. Were these pictures, why were these pictures taken? Why did you save these documents?
I saved these documents again to try to prove to Mr. Echard that I was indeed pregnant because he doubted me.
Did he ask you to send these documents?
Yes, he did.
To show why?
He asked for these documents to show that I was indeed pregnant and that the pregnancy was ongoing and that it was viable.
Have you altered any of these documents in any way to misconstrue their meaning
No, I have not altered them.
And are these an accurate reflection of these documents?
Yes, it's entirely accurate.
They are your documents?
Yes, they are.
All right, Your Honor, I'd like to admit Exhibit 46 into evidence.
Your Honor, I'm not objecting because I believe the court needs to see these exhibits, but I will note that we have concerns regarding what they're being offered for.
So I'll admit 46.
I'd like to take your attention to Exhibit 48. Do you have that in front of you?
I do, yes.
Okay, what is it?
This is a letter from the Arizona Department of Real Estate that they sent me after looking into Mr. Echard's conduct when he was my realtor.
So after the brief hookup, whatever you want to call it, they met and he showed her some properties. She asked him to put an offer in on 2 of them and showed him a printout of a money market account with a $400,000 balance. It was during that meeting that he told her, hey, listen, we're just going to be friends. And immediately after that is when the psycho texts and stalking and craziness started. He offered to refer her over to another agent broker in his firm to finish the deals, all that. She refused. He didn't put through the offers because he started questioning whether she had the money or not. So, he probably should have got some advice from someone else because, ethically, he didn't really do exactly what he was supposed to do. But given the circumstances, I kind of don't blame him.
Showing that he was found in violation of professional conduct for not submitting an offer.
Okay, was this something that you received from the Arizona Department of Real Estate?
Correct.
Did you alter this document in any way?
No, I did not.
Did you receive it on or about September 15th, 2023?
Correct.
Okay, Your Honor, I'd like to admit this into evidence.
I'm objecting for the record based on relevance. Again, this matter is about Ms. Owens' harassment of Mr. Echard. I do not believe that this is relevant.
I agree. It will not be admitted. 48.
Your Honor, how much time?
1 minute.
I'd like to turn to Exhibit 50, Your Honor. This will be the final one that Or Exhibit 50, do you recognize that exhibit?
Yes, I do.
Okay, and what is it of?
This is something that was posted to Reddit by Mr. Echard under a false name, and that was also in the order of protection hearing I had against him last week. It was discussed.
Okay, and did you change this image in any way?
No, I definitely did not.
How'd you get a copy of this image?
It was on Reddit. Somebody had created it, but I know it was Mr. Echard because only he had this image.
Okay.
Objection. She's testifying, Your Honor, regarding information that she cannot testify about. Speculating.
So you can have her lay a foundation that she has knowledge of.
Okay. It's your understanding that Mr. Echard posted this picture?
Yes, because only he had the photo and the sonogram I'm holding that's been edited. I think that's been edited.
Your Honor, I'd like to admit Exhibit
50.
50 at this time.
Your Honor, I'm objecting. This is inherently unreliable. She's failed to lay sufficient foundation. This was not posted by Mr. Echard, and she provided zero proof that this was posted by Mr. Echard or further that this was sent to Mr. Echard in this manner.
I'm going to sustain the objection and not admit 50.
Okay, nothing further at this time, Your Honor.
Cross-examination.
Your Honor, before I start with cross-examination, my request would be, if the court's willing to entertain this, that we be permitted to go until noon. And I would be willing to waive closing argument because I do have important questions that I would like to go through as opposed to presenting the court with a closing argument if the court would allow that.
Let's see how we're doing on time.
Thank you, Your Honor. Good morning, Ms. Owens.
Good morning.
You were thoroughly questioned by your attorney at the last hearing in this case on October 24th of 2023, correct?
Correct.
And you understand that you were under oath at that time, and you remain under oath today, right?
Correct.
And you're aware that any false testimony that you provided or provide today could be considered perjury, right?
Yeah, absolutely.
And so based on that, Ms. Owens, before I proceed with my line of questioning, do you have any prior testimony that you'd like to correct at this time?
I do not.
I want to make sure that you're clear-headed, and obviously it's your position that you are pregnant with alleged twins, correct?
100%, yes, correct.
What medications are you currently on?
Objection, Your Honor. Relevance, and that's an inappropriate question for this.
Overall, it can be impacting your testimony.
I'm on prescribed prenatals, and I'm on folic acid, and I also take lamotrigine for epilepsy.
Is there anything else? Is that your entire list of medications?
That's my entire list because I was taken off of anything else that I was on when I found out that I was pregnant.
And have you been diagnosed with any other medical or mental health issues?
Objection, Your Honor. I don't think that that's going into your mental health, going into your physical health, mental health. I don't think that's appropriate for this type of hearing.
Overall, I have a question.
Depression.
Okay, and any other physical health diagnoses?
Epilepsy.
And who provided those diagnoses?
All right, I think we're now over the report of that testimony.
Understood, Your Honor. I'll move on, please. And how far along are you as we sit here today with respect to the pregnancy?
I am 24 weeks along.
And when was your last menstrual period in order to calculate your due date?
Objection, Your Honor. I don't think that that's appropriate at this time. It seems like these questions are meant to harass my client. She's indicated she's pregnant. She's indicated the amount of months. You don't need to know things about her menstrual period.
I'm going to sustain the objection.
I'm sorry.
Can you please provide us with your alleged due date?
February 14th.
And you testify that there's absolutely no possibility at all that your alleged twins are anyone other than Clayton, correct?
There's no chance they're anybody else's.
But you understand that Clayton has been very clear from day one that he did not have sexual intercourse with you, right?
Clayton was not. If you look at the June 4th message,
Ma'am, these are yes or no questions. Do you understand that Clayton was very clear from day one that it's his position he did not have sexual intercourse with you?
Then the answer is no.
And as we sit here today, you have participated in 3 DNA tests to try to prove that Clayton's the father, correct?
Correct.
And not a single DNA test has come back.
Oh, I'm sorry.
Stating Clayton's the father.
Sorry, it was 2 DNA tests, not 3.
Well, you indicated at the last hearing that you were providing a sample for the 3rd DNA test to be completed, correct?
But the second one there was an issue with the transit according to the lab. So, I mean, that wasn't tested. So I can't say that I have had 3 tests that have come back with different results because only 2 were tested.
Ms. Owens, you've provided a sample on 3 separate occasions for DNA tests, correct?
Correct, but the second was
These are yes or no questions. I'm not looking for you to elaborate. So we'll move on. As we sit here today, not a single DNA test has come back indicating that Clayton's the father, correct?
The samples were diluted, and I'm going back next month, is what I was.
These are yes or no questions. It's a very simple question. As we sit here today, you have no DNA test that indicates that Clayton is the father, right?
The results, the testing is ongoing, is what I was told, as was Clayton.
So
So that's
you
not
said that on a couple occasions that the testing is ongoing.
correct.
So is it your testimony that you provide these samples and that there's no results that are coming from these samples you're providing?
I'm unclear on what you're trying to ask me, because they said that I
Okay,
need to
well,
go back a month to give another sample, that the testing is not back. So I'm unclear, I guess I'm trying to say.
isn't it true that the test came back and indicated there was zero fetal DNA?
That's absolutely not true.
Okay. And again, Ms. Owens, you have provided no testimony and no objective evidence or documentation to date to support that you have a positive DNA test proving Clayton's the father of your alleged twins, right?
The testing is ongoing. I'm unclear, I guess, is what you're trying to ask me.
Who is your OBGYN?
Dr. McCool
Your Honor, again.
and Dr. Higley.
I wasn't able to hear that, and I'm not sure if the...
I'll withdraw the objection, Your Honor.
Can you please repeat that, Ms. Owens? Who is your OBGYN?
My main OBGYN is the perinatologist, Dr. McCool.
And when is the last time... Oh, well, you said your main OBGYN. Who else are you seeing? What other pregnancy-related doctors are you seeing?
Dr. Higley, who I saw last Friday, and an epilepsy doctor as well. He specializes in pregnancy.
Okay. And in your exhibit, I believe it was 44, you indicated... Actually, let me go back here. I apologize. It was your exhibit 43. You indicated that all of exhibit 43 contains copies of your medical records that would support this alleged pregnancy, correct?
I believe it was exhibit 46 that was the proof of pregnancy. We didn't do exhibit 43.
I apologize. Exhibit 46, my mistake. And in that exhibit 46, all that you had from Dr. McCool here is a screenshot of an upcoming appointment for Monday, July 24th of 2023, right?
Correct. Because he's a doctor.
You understand that anyone can go online at AMOMI, where Dr. McCool works, and make an appointment for an OBGYN appointment with Dr. McCool, correct?
That is not true. Dr. McCool is a perinatologist. I have a referral to see him because I have epilepsy. He's a high risk specialist. You can't go and make an appointment with him. I had to send records to get an appointment with him.
Okay, but the only record that you have provided this court with regarding your alleged high risk perinatologist is a screenshot of an appointment for Monday, July 24th of 2023, right?
No, I provided the last page was October the 11th with the diagnosis epilepsy during pregnancy from my neurologist after an appointment that day.
Ms. Owens, there is no copy of any medical record from October 11th.
Yes, there is the last page. It's October 11th. If you look at the last page, Zeman Glennis on October 11th, 10:53:20 Mountain Standard Time.
I apologize. What was it that the court indicated?
A few more minutes, so we need to probably step it up a little bit if you want to get to other things.
As we sit here today, Ms. Owens, you have refused to sign any sort of HIPAA release so that Mr. Echard could obtain directly from your medical providers evidence to support any alleged pregnancy.
No, on Friday, I literally had the doctor send it to him directly. I had my provider send it to him directly, and that's an email I sent to him telling him that it was sent directly to him. I signed a HIPAA release.
Ms. Owens, this is not the first time that you've made allegations that you're pregnant with twins within the last 2 years, correct?
That is incorrect.
Okay. So I would ask the court to take judicial notice, Your Honor, of the civil matter involving Mr. Greg Gillespie, who is present in the courtroom today. And it's CV, let me get that number for the court,
I have a protective
2021
Gillespie and against Mr. Echard, and I wish I was aware that Mr. Gillespie
052893.
No, I'm going to object to that.
We had an exhibit that we discussed last time regarding that case, and what was presented was a complaint and a motion to dismiss, and there wasn't any findings from any court on anything related to that. So I'm not going to consider that at this point.
Your Honor, I do have some questions that I think are very important for the court to hear regarding that case. I understand if the court doesn't want to take judicial notice, but I do have questions that are important that I would like to proceed with regarding the uncanny similarities.
I don't think that would be appropriate for this specific hearing. We know the scope of this particular hearing. Bringing up things in a separate case, there's separate issues. These are not the same thing. This is an injunction against harassment. I don't even know what that case is. It's not an injunction against harassment. I know that. It's not appropriate.
Your Honor, this goes to the heart of why Mr. Echard needs this injunction against harassment, and Miss Owens' pattern, her modus operandi, her pattern of behavior, her pattern of making the same claims against other men in the state of Arizona within the last 2 years. And I think it's highly relevant to this case because it supports why Mr. Echard needs this injunction against harassment, because this individual has done this before, and there are concerns that she will not stop.
I'm going to sustain the objection. I'm not going to allow that testimony.
And Your Honor, I would ask, again, the court to reconsider here, because this matter, it's very important that the court hears how Miss Owens has made the exact same allegations in another matter within the last 2 years. And that she has committed perjury in her last hearing because she made she made false statements under oath regarding the nature of that case. She opens the door in her testimony when Mr. Lopez was when he was direct examining her regarding the fact that there are no other cases that are similar regarding things that happened in that case. So she did open the door based on her direct examination.
Your Honor, these are very serious allegations that the petitioner's attorney is now alleging against my client. She is insisting that my client has now committed perjury. My client has no criminal history and is not being charged with perjury. So I don't know, that's just an allegation. Again, these cases are completely different. We're hearing that the attorney testified that these are the same. These are not the same matters. These questions and this cross-examination of my client regarding these issues, again, would be inappropriate and is outside the scope of this hearing. In fact, it even sounds like she's trying to bring out character evidence, which would be inadmissible in a hearing like this.
I'm going to sustain the objection again. So if there's other things you want to ask about her testimony, Ken, you have about 2 more minutes.
Ms. Owens, you understand and you testified under oath that Mr. Echard blocked you from communicating with him, correct?
he would block and unblock. But not from communication. It was on a text number, but we were always in email communication as recently as the day before I went to the press. He sent me an email. So,
well, Mr. Echard told you he didn't want you contacting him anymore, and then would block your telephone number, correct?
But told me to email him.
Ms. Owens, these are yes or no questions. Isn't it true that Mr. Echard indicated he did not want you contacting him anymore and then would block your telephone number?
Actually, that's incorrect. From the early resolution conference that we had, Mr. Echard told me specifically to contact him via text I had forgotten that. If you look at the transcript from that hearing, you would see that. And I haven't contacted him via text after he told me to.
Okay, can you take a look at Exhibit 55 for me, please?
I don't have an Exhibit 55.
Your Honor, these are our supplemental exhibits.
That
These
we're
would have
not.
been the ones that are their exhibits that they would have sent you. It may not be marked by number. Is, I guess, the issue. Hers may not be marked by number.
They are, Your Honor. We sent them exhibits
Let me
marked
check
by
my
number.
email. I did not see his exhibits. Excuse me. Let me.
And Your Honor, I'm asking for more time because her not being prepared, knowing I presented these exhibits to her attorney yesterday, is coming into my time, and I have still several questions I'd like to ask.
I was not aware that he was getting more exhibits added after he already had testified, so I apologize.
Okay.
It says text messages between the parties dated 5/25/23. That's all I have. I don't have the actual exhibit.
That's the first one. And then there is another one after that. Do you see?
You have the exhibit that's from May 25th?
I don't see anything. I literally just am seeing a list of plaintiff's trial exhibits 55 through 63. Can you explain what the context is for me to understand?
Are you able to scroll down?
Your Honor, I'm concerned if she doesn't have these exhibits that we're going to need more time, because this is very important that I get through this testimony, and I provided these to counsel in advance to avoid this exact issue. And had Ms. Owens been present, this wouldn't have been an issue at all.
Right, but I have a protective order against Mr. Echard.
All right. Just, can you find the exhibits or not?
Let me just try to see if I could scroll down. Hang on. Maybe if I make my screen smaller. Oh, yes, I do. Hang on. I think I see them. I see exhibit 55. Yes, I do.
Okay, go ahead.
Ms. Owens, do you see exhibit 55 is a text message communication between you and Clayton dated May 25th of 2023, correct?
Correct. The day after he didn't file the...
I would move to admit these exhibits, Your Honor. This exhibit.
It's not testimony. She's asking if you recognize the exhibit. Any objection to 55?
I don't remember sending
I'll
it.
admit 55.
And here, Ms. Owens, on May 25th of 2023, Clayton says to you, I'm debating filing a police report. Please leave me alone, correct?
The context needs to be stated. He did not make
Ms. Owens, I am
$1.1
asking you yes or no questions.
And he was found in violation.
Your attorney will have the time to ask you a question again, Ms. Owens. So just answer her question, and your attorney will have an opportunity to question you again.
Okay, then can you? I'm sorry. Can you repeat the question? I'm sorry. This is ridiculous.
I'm concerned that she's doing this intentionally to eat into
All right,
my
let's
time.
just ask the questions. You're wasting more time saying all that stuff.
Ms. Owens, isn't it true that on this text message dated May 25th of 2023, Clayton responded to you and said, I'm debating filing a police report. Please leave me alone, correct?
That's what the text message says. I don't have that, but sure.
And right below that, you sent him another text message, correct?
That's what it shows, correct.
Okay. Can we move to Exhibit 56? It should be the next page of the document, please.
Your Honor, how are we on time? Because I know you said 3 minutes. I understand.
We're close on time, so I want to leave everyone time to do a closing if they choose to.
You see these emails between you and Clayton dated June 28th of 2023, correct?
Correct, but the middle email is missing from him, but correct, yes.
You're going to move for the admission of Exhibit 56, please?
But it's missing the middle email.
Yeah, Your Honor, I'm going to object because this isn't everything in whole. You can see that there's an email missing between these two emails. There wasn't any foundation that was laid.
But this was one of many emails sent between the two of us. Clayton changed his mind many times.
I guess just referring to these exhibits. Do you recognize these exhibits? These messages?
I mean, that's what they said. I haven't gotten to read through them, but I mean, that's what it says.
Do you believe these are a representation of the exhibits of the emails that were sent?
I know that my name when I email somebody else has a picture of me with a horse instead of the LO, so I don't know if that's relevant, whereas like Clayton's picture is shown with Clayton Echard, so I don't know if that's relevant. If I read these quickly, I can see if they are mine. I'm going to trust that they are mine, but I haven't gotten a chance to read through them.
Your Honor, she did testify that she recognized these to be emails dated June 28th of 2023. So I'm asking for their admission.
Again, the middle email is missing where Clayton tried to trap me, but
Your Honor, I'm asking if the court strike that there's no question before her right now regarding that.
I'll strike that statement. I will go ahead and admit Exhibit 56.
In Exhibit 56, Ms. Owens, on line 1, you say, I just need clarity as to what we are doing. I've offered to give you control over the outcome of the pregnancy if we date exclusively and care for each other, correct?
Correct, which was one thought on one day, and I took that away after, yes.
And this is the exact same statement that you made to Mr. Gillespie back in July of 2021, isn't it?
I have no idea what statement I made to Mr. Gillespie, but both pregnancies have been medically proven, and I have the documentation and sent it.
But Ms. Owens,
all right, we can't keep everyone talking over each other.
I sent the HIPAA records. I released my HIPAA records.
Ms. Owens, there's no question before you. Your Honor, I'm asking the court to strike these statements.
All right, so let's try to just answer the question.
I don't know what I said in 2021.
Okay, so if you don't remember, just say, I don't know what I said.
I don't know.
That if I said that. Okay,
I don't know.
There we go.
Yeah.
All right, so we have room for like one more question, and we're going to be doing closing argument.
And Your Honor, again, I would just ask that in lieu of closing argument that I be permitted to ask.
I've already done that.
Okay.
We're already at 11:56 at the moment. So,
okay, Your Honor. And here, Ms. Owens, isn't it true that you alleged you were pregnant with twins with Mr. Gillespie in June of 2021?
No, that was an email that he doctored in 2021 that I have already testified about that in the other case. So no, I never said I was pregnant with twins.
Can you please take a look?
Again,
at our exhibit.
This was an exhibit that, whatever it is, I'm guessing I know what it is. It was one message that was doctored by Mr. Gillespie that appeared a year into the court case I had with him.
Right, and we've already discussed the fact that I'm not really considering all of that. So let's move to closing.
Your Honor, my concern here, and again, I mean this with all due respect, but Ms. Owens has a pattern of behavior here. She has previously made identical allegations in another case. The exhibits that I have today, as supplemental exhibits, all support that the statements she's made to Mr. Echard are almost identical to statements made to Mr. Gillespie in 2021. This is highly concerning behavior. She has now perjured herself on several occasions during testimony, and I am not being given the opportunity to show the court the documents to support that she is lying under oath.
I have proven my pregnancies and had my records sent to Mr. Echard.
Okay, Ms. Owens, Ms. Owens, we're not testifying right now.
I'm sorry.
Even if it was true that Ms. Owens did that in the past, which we are denying, But even if it was true, that has no relation to this specific case. Just because she may have done it before doesn't mean she's doing it now. And we have presented evidence showing that she is pregnant. We have presented evidence showing why
that's
she is.
false.
We're going to do closing arguments now. So whoever wants to do a closing argument, Ms. Arena, go ahead.
Your Honor, this is a clear case of harassment. The court has seen through all of the exhibits submitted by Mr. Echard and the additional exhibits that we presented today that the parties had an encounter in May of 2020. Mr. Echard did not have sexual intercourse with Ms. Owens. Shortly thereafter, Ms. Owens began claiming she was pregnant with Mr. Echard's child, with an alleged child. Mr. Echard repeatedly, from May to today's date, has pleaded with Ms. Owens to stop contacting him. He has blocked her number on several occasions, and she gets a new number and or uses an app to continue contacting him. It has not stopped. Mr. Echard has lost job opportunities, speaking engagements. He has suffered extreme emotional distress over these claims that are baseless and over her repeated outreach attempts after pleading with her to stop. This is the definition of harassment. The court's well aware harassment is defined per the statute as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Ms. Owens has fabricated a pregnancy now twice on two separate occasions. Mr. Echard is the second victim of this. She has provided no medical records to support that she is in fact pregnant. As the court saw, her Exhibit 46, Your Honor, is not medical records to support a pregnancy. It is merely, and I'd like to draw the court's attention to this, it is a picture of a test completed at Banner on June 1st of 2023 regarding HCG. It does not say it is a positive pregnancy test. The next page, Your Honor.
Oh, I'm sorry.
This is not your turn.
I'm sorry. It does. Okay.
It's not your turn.
It is very questionable, as a woman who's been pregnant before, that Ms. Owens goes to Banner to get an alleged pregnancy test on June 1st, and then she never goes back to Banner Health for any additional testing. The next page of this exhibit is simply a screenshot of an upcoming appointment with a Dr. McCool on Monday, July 24th, 2023. There are no records to support that she is an active patient with Dr. McCool, that he is her perinatologist. There's nothing. We just have a screenshot of an appointment that was made, which anyone can do online. The next record, Your Honor, this is now a HCG test from any lab test now in Scottsdale. This is not a positive pregnancy test. This is a positive HCG test. Why is she going to a new provider for a alleged pregnancy test on October 16th? These next two pages of records, Your Honor, it's hard to tell what they are. They look like they are screen grabs of an appointment, but it's unclear. It's just unclear. At the root of this case, and the reason that Mr. Echard is fearful, he is scared, is the fact that there has been a fabricated pregnancy. She has participated in several paternity tests, none of which have come back showing any proof or any signs of fetal DNA, Your Honor. If it wasn't for the fact that she has done this before in another case, this is unbelievable. It is very alarming. She lied under oath, and she lied under oath at the last hearing. She's not being truthful today, and my client is legitimately fearful of what else she's capable of. He's asking that this court recognize that he has done everything to handle this appropriately. He has begged and pleaded with her to stop contacting him. There is no reason for these two to have communication, despite what Ms. Owens will say regarding this alleged pregnancy. There is no proven pregnancy at this point. So we are asking that this court find that she has harassed Mr. Echard from May of 2023 up until today's date, and we're asking that the court find that the injunction against harassment needs to be ordered and maintained.
Thank you, Mr. Lopez.
Yes, Your Honor. Now, I would agree with Clayton that Laura's communications with him were alarming, annoying, harassing, if, in fact, Laura wasn't pregnant, and if, in fact, he wasn't responding to her through the over 4-month period that she's been pregnant. She is pregnant, and he has been responding. Clayton has not met his burden in this matter. He's claimed that the amount of text and emails has caused him to be alarmed, annoyed, harassed. Well, for starters, the reason there are so many emails and text messages is because the chosen form of communication between Laura and Clayton was through emails and text messages. And because that was how Clayton wanted them to communicate. Not in person, not over the phone, but through emails and text messages. And second, we are talking about a span, again, of over 4 months or more. There are going to be a lot of text messages during that time. There are going to be a lot of emails during that time. Third, he claimed in his petition that he has not responded to Laura and that he has blocked her. Now, that is clearly a lie. And
Sir, I would object. That misstates the evidence. There is clear evidence to support that the messages are showing from a blocked sender. That is not accurate.
Your Honor, some of those messages may have been blocked, but there are other communications in the exhibit, in Clayton's own exhibit, that state, that show that he did respond to my client, whether it be in emails or text messages, and we've provided those some of those exhibits in the ones that were admitted to this court. Now, Laura testified that there was communication even aside from the exhibits that we've presented. It's impossible to put all the communication within over 4 months into a short hearing, essentially. Now, I want to talk about the content of that communication. All of the communication from my client to Clayton was meant for legitimate purposes and not to annoy him, not to harass him, not to alarm him. Almost all communication between Laura and Clayton was for the purposes of the pregnancy and paternity. The only other sort of communication from my client toward Clayton was in relation to the post that he put online when my client would receive harassing messages from Clayton's fans and his followers. So the communication around that time, call it August, September, was toward Clayton asking him to take those different things down so that my client wouldn't be harassed. Throughout this entire time, since May, Clayton has never been clear with what he's wanted to do. He's been wishy-washy the entire time. First, he didn't believe that my client was pregnant, so she sent him proof, and she sent him proof again. He wanted numerous forms of proof. You saw in our exhibit the video of Miss Owens pregnant. That was a video that Clayton asked my client to send to him. How can you ask someone to send you proof of their pregnancy and then now call it harassment? Now say that you're alarmed. Now say that you're annoyed. Now say that you're harassed. That doesn't make any sense. He was also wishy-washy about what should be done with the unborn children. And we're talking about at the beginning, around May, June. Should she have the children? Should they be aborted? Are we going to give them up for adoption? Am I going to have sole custody? Is she going to have sole custody? He was never consistent with what he wanted. I'm sure maybe he thought one thing one day and maybe he thought something else another day, and then he thought back to we didn't know what he wanted. And that was communication that was going both ways, back and forth between Clayton and Laura. Again, he hasn't been consistent, and that is what the root of this problem is. That is why there's so many communications back and forth. Had this been done in person, had they chosen to meet up physically or talk over the phone, things wouldn't get lost in translation through email, through text. But that's how they chose, that's how Clayton chose how he wanted communication with Laura. And that's what made everything so difficult. During this time period, Laura actually had to hire another attorney to help facilitate paternity testing. That didn't work, so then Laura had to file a matter out of the family court to create a
These are
parenting
not
plan.
facts and evidence at this time. These are exhibits that Mr. Lopez did not get to present.
I think she testified that she filed a paternity lawsuit.
And they did not have, neither of them, my client nor Clayton, have had an attorney in that family matter, so they are forced to communicate with each other because they needed to meet and confer. They needed to submit a resolution plan, so there's going to be text and communications back and forth from the two of them. Everything that you've heard during, whether it was our case in chief or the petitioner's case in chief, this is a snapshot of what has happened over the course of over 4 months. We were not able to present everything. All communication between my client and Clayton were for legitimate purposes. Again, not to harass them. Look at the exhibits. Look at the ones that Clayton submitted. There are clear exhibits that show that he was sending messages to her. We had submitted exhibits showing that Clayton had been communicating with her. So the fact that in the petition itself states that he had not responded to her, that's completely untrue. He had indicated in his petition that my client had harassed him. Well, that's not what happened. Who was the one that was posting videos online and getting harassed? Clayton was posting the videos. My client was getting harassed. Not one communication. There wasn't one communication that indicated after they had been in communication since May. Since then, there was no communications that were sent to my client telling my client, stop texting me, stop emailing me, stop calling me. Not one. They presented one exhibit that shows one message that indicated that, oh, I may call the police, something like that. It seems like he might be worried. But since then, he had been communicating with my client. So again, you can't say that you are being alarmed, annoyed, harassed, but then going ahead and then emailing my client, texting my client. And again, for all of those reasons, I think that the communication between my client and Mr. Echard were for legitimate purposes for to determine pregnancy itself, moving into determining paternity itself, to trying to schedule paternity testing with the attorney, to the family court matter, and to today. And so for all those reasons, we're requesting that this be dismissed. Thank you.
Your Honor, in rebuttal, none of the communication from Ms. Owens to Clayton has been for a legitimate purpose. As the court has heard today, it is clear there has been no DNA test or test of any kind to support that she is allegedly pregnant with Mr. Echard's twins. There is no reason for these parties to communicate. What Mr. Lopez is proposing is that if you block someone, but they find another way to contact you, and then you tell them you still don't want to talk to them in a polite email or a polite message, then that's not harassment. That is the epitome of harassment, Your Honor. The court has received exhibits in the first hearing from Mr. Echard supporting that she would find other avenues to communicate with him after he had blocked her. Again, it is Mr. Echard's position that that this pregnancy has been fabricated. And I want to be clear on this, Your Honor. It's possible that Ms. Owens is pregnant, but it's my client's position that he did not have sexual intercourse with her, and she is not pregnant with his alleged twins. And that is the root of the issue here. There has been no support for this alleged pregnancy, other than her attempts to show the court and or Mr. Echard a picture of her alleged pregnancy, which again, we suspect may still be fabricated. So there has been no legitimate purpose to her communication other than to harass Mr. Echard to try to force a relationship on him. She told Mr. Echard on multiple occasions that she was going to force him to communicate with her, whether he wanted to or not. And he has been clear. He does not want any additional communication from her.
All right, thank you. So, as I stated when we first started this hearing, I'm not making a determination as to whether or not she's pregnant or not. That is a family court matter. That case is pending before the family court. The testing or whatever is going to happen is a result of that. So I'm not making a decision and a determination today whether or not there is a valid or invalid pregnancy. I understand Mr. Echard's position is there isn't. I understand her position is there is. That's where we are at the moment. With regards to the evidence and the communication, the court at this time does find there were a series of events that were aimed at the plaintiff that would cause a reasonable person to be alarmed, annoyed, or harassed, that he was in fact alarmed, annoyed, or harassed. I do find they did not serve a legitimate purpose. Messages that have been sent. One, he blocked her on numerous occasions. She even said in the blocking communication, can you unblock me so I can unblock you again? I got a new number and then there's another new number. I think that's clear that he does not wish to have communication. Nature of the communication, while maybe surrounds the pregnancy, the communications that I have a lot of concerns with are the ones where she's trying to make offers to him to continue a relationship, that she is trying to facilitate. If you do this, then I'll give you this. Those kinds of messages are of the nature that are harassing and can be viewed as alarming, annoying, or harassing. There are a number of messages that were admitted that are attempts at, I view kind of almost as trying to, get him to do and agree to things that are not necessarily, it's not like we said, hey, can you take a paternity test? And he said, no. Hey, can you reconsider? I want to do a paternity test. And then I went and filed a lawsuit because you wouldn't do it. I mean, that's one thing. 500 emails back and forth or messages, I'll say text messages and emails over that period of time to try to clarify and do that is beyond what was necessary to be able to communicate those things. There were a number of threats to go to the media, which were other additional attempts to try to use the media as manipulation or the threat to go to the media as manipulation. I find those to be alarming, annoying, or harassing. So I am going to grant the injunction at this time. The injunction is going to prevent any communication outside of the legal process, and specifically legal process and court hearings. So I am going to grant the injunction, and so I will sign the granted injunction today, and then I know Ms. Owens isn't present, but we can give a copy of the signed injunction, obviously, to Mr. Lopez today, but whether or not ultimately she needs to be served with it so that the service of the injunction is appropriate, because it will go into effect once the injunction is served upon her. It would remain in effect for a period of 1 year. This was the hearing that she had as a result of that, so there's not an additional time to request an additional hearing. And if you guys want to wait for a few minutes, I'll sign an order. If there were exhibits that you did not offer that you wish to have returned to you, you can let the clerk know and she can release those back.
Thank you, Honor.
Right, thank you.
Thank you.
Thank you.
I'm not sure if her screen froze or if she's just kind of stunned, sitting there looking lost. From what I've seen, she's not used to losing, so she doesn't take rejection well and is probably having a little bit of a hard time with this. Hopefully she's got a good therapist, because I don't think deep breathing exercises are going to fix this one. But I'm glad to see some common sense coming into the case. I got a little worried in the last one when a protection order was issued against Clayton for the revenge PORN, which was a picture of her pregnant belly that she put in a public Dropbox on Reddit. Like, give me a break. Anyways, we're on the right track. I wasn't sure how far off the rails we were gonna go, but we're good. We're on the track. We're going. We're following the law. After this hearing, things settled down a bit. In the court case, of course, there was still daily battles going on online, and attorneys were doing what they do, writing lots of stuff, putting in lots of motions, killing lots of trees, all that. At some point, either in November or early December, Owens' attorney actually withdrew from the case, and she replaced him with Alexis Linville, also known as Lexi. Clayton hired an attorney, Greg Woodnick, who also represented Greg Gillespie, which Laura Owens also has a questionable lawsuit pending against in the same court. Woodnick immediately filed a motion to amend the original response. Specifically, he was asking that they be allowed to make updates to include pertinent background information. If you remember, Clayton started this case off pro se, so he wrote the initial response himself, which is great. Clayton is by far the most talented pro se that I think I have ever seen. He did amazing in the court cases. However, attorneys know exactly what to do, what words to say, how to formulate things, and what information to give, and have a leg up. And it's a lot safer to let them write those things. So revising it was definitely a thing. He also asked for the court to sanction the petitioner, which is Owens, under Rule 26. This was the beginning of the Rule 26 saga that is still playing out to this day. Woodnick asked for reasonable attorney's fees and requested the court to enter a finding of non-paternity. So this motion was filed on December 12th, after the second DNA test came back with little to no fetal DNA found. I think after 2 tests with no fetal DNA found, it's pretty safe to assume that Clayton's not the father. And probably no one is. But that's just a guess. The following day, Woodnick filed a second motion, an expedited motion to extend dismissal date on the inactive calendar and schedule an evidentiary hearing. So this would keep the case from being dismissed, because earlier in the month, the case had been placed on the inactive calendar because nothing was going on in the case. They were just going to dismiss the case. If they dismiss the case, both Clayton and Laura walk away like it never happened. I mean, of course it happened, but, you know, nobody loses or wins. You're just done. And that's not really fair because one party was injured by this, in their opinions. So Woodnick wanted sanctions. He wanted his fees paid. So by keeping it on the calendar and having a hearing, that makes that possible. If it had been dismissed, then that would not be possible. That would be the end of it. Move on. He noted in that there had been no substantive or scientific proof of the alleged pregnancy. The test indicated little to no fetal DNA. Despite this, the petitioner was still claiming publicly that she was pregnant with twins. And as a result of her threats, Clayton was forced to register on the Punitive Father Registry. I don't know what that is, but it sounds really scary. The Punitive Father Registry was established by Arizona Revised Statute 8-106.01 and is maintained by the Arizona Department of Health Bureau of Vital Statistics. A punitive father is a person who claims to be the father of a child and wants to establish paternity. This person also wants to receive notices of any adoption proceedings concerning the child. What is the purpose of the Punitive Father Registry? It serves 2 purposes. It enables a punitive father to notify interested parties of his claim of paternity so that he can receive notice of any proposed adoption proceedings, and it protects the security and stability of adoption proceedings. A punitive father who files a notice of claim of paternity before the birth of a child or within 30 days after the birth of a child is entitled to receive notices of any judicial hearings regarding the child's adoption. I'm sure there's a court case that led to this. I just haven't looked it up. It's basically saying mom can't not put the father on the birth certificate and then go and give the child up for adoption, and dad doesn't find out about it till years later and then fights to take the kid back from the adoptive parents. I know we've heard of that happen. They also asked for a finding of non-paternity again, and they asked for a 60-day adjournment so that the defendant can receive discovery, which they have not yet received. I love this. Though respondent vehemently denies that petitioner is pregnant by him, he is entitled to discovery. That he is. And that discovery includes verified, not edited or otherwise fabricated medical records. Where do you get those at? A week later, on December 20th, Laura posted the infamous Facebook crying video. Then, to end the year with a bang, petitioner Laura Owens' attorney filed a response to Woodnick's recent motion, asking that it be denied in full and the case be dismissed, which we all expected. That's the correct response to that. However, the notation was, this is no longer a paternity case. The petitioner is no longer pregnant. Dun dun dun. To be continued.